All right, so let's get started. All right, so we've designed the syllabus to basically follow this crescendo from legal document management to legal infrastructure to computational law. And last week we had our introduction to computational law, and we talked quite a bit about how computational law can help towards more access to justice in the future. Since we think the area of access to justice is one that computational law techniques can be used to great benefit. So what do you think is the other great area for application of computational law? Anyone?
Well, I'm sure everybody's not answering because they assume that computable contracts are part of computational law.
Oh, okay, all right, okay, good. So the other great area for application of computational law is contracts, and so that's why we've added this session on computable contracts to the syllabus. In fact, we're actually so excited about the contracts area that we're in the process of building the Stanford Computable Contracts Initiative, which actually Harm will be leading. So it's a very exciting area for building contracts that computers can understand and the computers can work with. Okay, so for this class today, we decided to invite one of the leading academics in the field, as well as two of the top legal tech entrepreneurs in the computable contracts space. So our first speaker will be Professor Harry Surden. He will, set up the discussion. He's a professor of law at the University of Colorado in Boulder, where he focuses on legal technology, but also on IP law. Prior to joining the faculty of the University of Colorado, he was actually the first fellow with our center. So Harry and Codex go way back. When he was a fellow in Codex, he also was working on, at the time, what was called the Stanford Intellectual Property Litigation Clearinghouse, which is now known as Lex Machina, and we've already heard a lot about Lex Machina. So Harry got his JD degree from this law school, graduated with honors, and before going to law school, he was actually a software engineer with Cisco, as well as with Bloomberg, and he received his undergrad degree from Cornell University. So I think before I introduce our other speakers, I will just turn it over to Harry so he can get us started.
All right, great. Well, thank you for that kind introduction, Roland. It's always good to be back. Is the audio okay? Can you hear me?
Just fine.
Yeah, I can hear you well.
Okay, great. I was just going to suggest that AJ maybe put his microphone on mute, because I think we're getting a little bit of feedback.
Yep, I'm just going to do that.
Okay, great. All right, great. Well, thanks so much for having me. It's really great to be here virtually. I wish I could be there in person. Stanford is near my heart, and I try to get back there as often as I can. Work with all the great people like Roland and Mike and all really great, interesting people there. A lot of great stuff going on. So today I'm going to talk about computable contracts. If you're interested, I think Roland sent out the article, based on the article published in basically last year. There's a link if you're interested in UC Davis Law Review. But just generally speaking, just to frame the discussion, this is about the representation of law or legal obligation in computer understandable or computer actionable form. Right? So what does that really mean? It means to represent law in a way that the computer can do something useful with, tell you something about liability or something else related to a legal obligation. The computer is helping to come to some useful conclusion about the law. So I think a computable contract is just one example of computable law generally, which really might happen anywhere within law. So let's just start with the basics. I'll talk about computable contracts. I'm sure most of you know this, but what is a contract? It's a legally enforceable promise to do something in the future, usually with some specified terms and conditions. All right, so I promise to sell you 100 shares of Apple stock at whatever price it is on January 10th, 2006. Right, so there's some terms and conditions and a promise to do something in the future. So what is a computable contract? A computable contract is a contract that has been deliberately formulated and expressed in such a way that the computer can understand what the contract is about and can also determine whether or not one or more of its promises have been complied. Right? So that's the outset. The computer is out there figuring out what the contract is about, and in some cases determining conversation compliance with one or more of the applications. So my goal today is to explain the intuition behind how a legal contract can become a computable contract with obligations computed. All right, so is everyone with me so far? Yeah?
Yeah.
Yes.
Yep.
Okay. Excellent. All right. So let's first understand the background that motivated computable contracts. So can a computer today understand your typical legal contract? And in general, the answer is no. So let's explore a few reasons why computers today generally can't understand your typical language contract. And then we'll understand how computable contracts serve as a partial workaround for some of these problems. So the first problem is what might be called the natural language processing problem. Right? So some of you may know that computer scientists refer to the ordinary language that people use to communicate with one another, written in English, for example, as natural language. And the variant of computer science that studies automated processing is natural language processing. So at least in the United States, your typical legal contract is written in legal language, which is, we all know, is an impenetrable variant of English, understandable largely by lawyers. So I'm probably the only one that complements legal language by calling it natural, but it's only natural from the perspective of computer scientists by comparison to the highly structured, mathematically formal languages that we use for programming. Right, so the upshot is that today's contracts are written in legal English, that is natural language, and the main problem is that computers are not as good as people at understanding natural language. Right, so while there have been major advances over the last 15 years in understanding natural language documents, still today a computer can't understand a natural language document at the level of a lawyer. So that's problem number one. Problem number two is related, and it has to do with subjectivity and abstraction. So contract terms often contain words of subjectivity or abstraction, things like reasonable or best efforts. A lot of times this poses almost no problem for people. For computers, however, determining reasonableness and other abstract terms is problematic. Right? So computers are not as good as people in working even at very clear areas of abstract legal terms. That's problem number two. And then problem number three, of course, is uncertainty. Right? And that's what law school is all about. I teach law students, spend a lot of time dealing with legal uncertainty. That's often why lawyers get hired, because they're operating in environments of uncertainty in the law, uncertainty in the facts. Nonetheless, your clients need some sort of counseling, even though there's not a lot of certainty. So uncertainty is a way of life in law. It's hard enough for people, let alone for computers. So that's our background of these problems. And you might think that given these three problems, these technological and legal impediments, it would be impossible for computers to automatically accept contracts, but that is not the case. There actually is an approach to automating some subset of contracts, not all, provided it is done in the appropriate context. Right? So that's the computable contracting approach, which we can think of as a partial solution or workaround to the three problems we just discussed. Right? So there are three steps to computable contracting, which I will talk about shortly, but here they are. Number one is data-oriented contracting. Number two is semantic contract terms. And number three is automated assessment. I'll talk about each of those briefly. So what is a data-oriented contract? So recall that computers are, that we normally write contracts in English, and computers have a hard time understanding English because it's natural. Right? So easy things that would not fool a person would easily trip up. So why do we need to express contracts in English? Well, it turns out we don't. In a data-oriented contract, the parties express the contract not in English, but as a data object, as highly structured data and programming language that the computer can parse with absence of ambiguity. Right? So this partially gets around the natural language processing problem because we're not asking the computer to understand the matter of the contracting parties are expressing their contract in the language of the computer. So to be clear, this often confuses people. We are not, there's something called taking an English language contract and overlaying metadata or semantic data on top of it. That's not what we're talking about here. We're talking about expressing the entirety of the contractual obligation and promises in computer data and rules. Right? So in essence, how this works is the parties who are agreeing to a contract come to an agreement about the meaning of data upon which the contract is expressed. So just to begin, here's a very oversimplified example on my slide here, but say you have an option contract, right? And your option contract might have an expiration date, and you might normally express it in English. Sorry, is there someone talking? Is that just feedback?
No.
Okay, sorry, there's some strange feedback. So you might normally say, hey, this option is the option to purchase is going to expire on January 18th, 2015. You can also express it in highly structured data, like the bottom version, where basically the contracting parties get together ahead of time and agree on some standards that the bottom format is equal to the top. Right? So that's a highly formal data structure, the bottom that the computer might be able to parse without any problems, where the computer would have trouble parsing the top. So that's number one, data-oriented contract, expressing your contract as data. Number two is, in some cases, more interesting, and that's semantic contract terms. Right? So what does that mean? In some cases, but not all cases, you can decompose or translate contract terms into an analogous set of computer rules. And in other words, the computer has the rules that it can use to automatically follow out the logic of whatever has been signed. Right? So let me give you an example here. So if we have an expiration date, and you want the computer to know what an expiration date is and to follow the logic of what an expiration date is. How does the computer do that? The answer is that we tell it. You give it a set of computer rules that carry out the logic of what it means to have an expiration date, and the computer simply follows those rules, and it's following basically the same logic that a person would have followed. So just to give you, here's another oversimplified example, but if you have the option to purchase shall expire on January 18, 2015, you can, in this case, provide an analogous set of computer rules where you say to the computer, don't execute this contract if the current date is after January 18, 2015. So this is really interesting. This is what means to semantic contracts. You're giving an actionable set of rules. The computer can do it on its own, carry out the logic of whatever the substance of the contract has promised. And I want to point out that this is limited because not all, or even maybe most, contractual terms or conditions are easily translatable this way to a corresponding set of computer rules, but interestingly some are, right? And if they are, then they're automatable. So that is pretty cool. I think that's kind of the big in computable contracts. And then number 3 is automated assessment of contract terms. Right? So I said that a computable contract means in part that the computer can go out and figure out whether some of the contract terms have been complied with or not. So how does the computer know whether a contract has been complied with or not? Well, it turns out that contracts often, or usually, hinge on conditions that happen out there in the real world. Right? So your contract, whether the promise happens, is contingent on something either happening or not happening in the real world, something that was promised. And today, interestingly, a lot of this data about what's happened in the world has been captured in computer systems. They're stored in databases that are networked and accessible, things like stock prices or other data about the state of the world, or transfers of money. In some cases, computers can harness the fact that data about the world that is relevant for the contractual obligation is stored somewhere, and you can basically tell the contract, hey, go out and look at this data source that we both agree on is indicative of a contractual promise. Reach out and look at this data, and then you'll know whether or not, at least, it looks like the contract promise is being complied with. Right, so this is what I call automated assessment of contract terms, which is you have an agreement, and then you provide the computer with a source of data that is relevant to determining whether or not the agreement has been complied with, and then the computer on its own can reach out there and make the decision, or at least what I call prima facie decision. Right? It can say, at least given the data that I have determined that this promise has not been complied with. Right? So those are the 3 steps for computable contracts. And lest you think that this is just a theoretical example, let me point out that most financial contracts these days, so contracts to purchase derivatives or any sort of financial instrument, almost all of them, hundreds of billions of dollars of these contracts, are computable contracts exactly as the source has described. The contracts don't exist on paper anymore, for instance, to buy a derivative contract. Rather, a contract is now only a data object that exists in databases between 2 contracting parties, and these contracts have the ability to reach out there in the world to these clearinghouses to determine things automatically on their own whether certain promises have been complied with, for instance, whether money has been transferred from one account to another, or ownership of a financial instrument has been exchanged. So all this is automated. It's really a phenomenon of the last 5 to 6 years. It took about 10 years for the financial industry to get their act together and agree on standards and agree on a lot of what are called massive contracts, which are actually English language contracts that form the foundation of subsystem automated electronic contracting. So let me just close here, and I'll take questions. I want to point out some really interesting new properties of computable contracts that regular English language contracts don't have. So I already talked about one, which is automated assessment with some contract terms. Right? In the past, a lawyer maybe would have had to read English language contract and then call somebody up to figure out whether something has been complied with. These days, all that can be automated under certain circumstances, not all. I think perhaps a more interesting property of a computable contract is the following. Because computable contracts are data structures, computer data structures, contracts can now become inputs to other computer systems. in a way that English language contracts cannot. So you see this in finance these days, for instance, where you can take financial contracts that are data structures and feed them into risk assessment systems, and the contracts just become input where financial houses figure out how much they have at risk at any given time. There's lots of other interesting opportunities for using contracts as input to systems. So, for instance, a large company like Cisco with millions of contracts might be able to automatically determine at this point whether they've promised the same object to two different parties at the same time, which would be a conflict. Today, such conflicts are difficult to detect, but they are much easier to detect once contracts become inputs that are analyzable by other computer systems. So I don't want to oversell this, and I just want to point out that not all or most contracts, I believe, are amenable to this. The vast majority of contracts, I think, are not. However, some subset of contracts are, and there are certain properties I've written about that make a contract more amenable to this, but in short, it has to do with things like finance, where you have a lot of well-defined objects that everybody agrees with, a lot of standardization. Things rarely go wrong, so the error is the exception to the rule. So because of this, I think only a certain subset of contracts are amenable to this, but those that are likely to be automatable. However, the good news for law students and law professors like me is that lawyers are still in business. I don't think we're going to be automating away all contracts anytime soon. So, I'll stop there. I've been talking for a while. See if anybody has any questions or comments about computable contracts. And it's been a pleasure talking to you. I look forward to hearing your thoughts.
Thanks, Harry. Any questions at this point?
One thing I was wondering, Eric, can you hear me?
Yeah, I can hear you.
Okay, one thing I was wondering is if you thought about the implications for regulation of these type of contracts. For example, especially in financial derivative contracts, there's a possibility that writing in a certain way can cause things like the financial runs we saw in 2008, 2009. So I was wondering if you think that kind of thing would ease the burden on regulators, and if they were at all part of the master agreements that you're discussing.
Yeah, that is a great question. So I think there's an undercurrent to your question that all is not necessarily rosy with computable contracts, meaning that they can cause a lot of problems if we're not careful. And one of the reasons that the financial crisis happened, a lot of people say, is that these computable contracts gave financial houses an unjustified view that they had a handle on the amount they had at risk, when in fact they did not. There was a false sense of security, and there's also worries about, by reducing the friction, by automating things, that small errors can more quickly propagate throughout the system. So we really need to be worried about both the costs and the benefits of reducing some of these frictions in the system. I think in terms of regulators, I think it's very promising. I've heard that regulators are doing some automated techniques to increase compliance, but I've not heard them using anything related to taking advantage of the computable contracts themselves. So I think they're doing statistical analysis, so I've heard. But I think they should.
There's another question.
I guess I just had a question. Can you hear me?
Yes.
Cool. I guess I just had a question in terms of these computable contracts. Do you envision the entire contract being data-oriented, that it can be read, or just particular terms that lend themselves to this with ancillary, either an ancillary contract or in that contract, natural language?
Yeah, that's a great question. So so I call it the idea you sever off the computable terms. So I think the general idea is that you don't need to make every part of every contracting relationship computable, nor do I think we can. Rather, you sort of computerize and represent data, the parts that you can, and the parts that you can't often exist in sort of a master contract or part of the background rules. And that's basically how it's worked in finance these days, where, you know, if something goes wrong with one of these computable contracts, they fall back on their master agreement, which has rules about what to do when things go wrong and how to deal with that. And I think that's sort of a pretty good model for how a lot of this is going to happen in the future.
Great, Brian.
Hi, can you hear me?
Yes.
I just had a quick question. Given the current state of natural language processing, it seems like semantic parsing is a less reliable method than what you were talking about, where the lawyers entered the structured data and the contract terms in a more computable form directly. I was wondering if you had seen any movements by organizations to try to create a standardized provision to get lawyers to really do these things, or if law firms have started to adopt particular rules for lawyers who are writing contracts to write it more in a computerized, structured form in order to gain the benefits from doing so?
That's a great question, and the answer is largely no. And this is, I think, one of the big problems with holding this idea back is the absence of infrastructure to both technological infrastructure. There's actually some technology that needs to happen, probably open source, to make these. I think more importantly, there's standardization issues that have to be overcome. And for instance, it took, from what I've heard, it took the finance industry 10 years to agree on a standard set of terms. And they actually had multiple sets of terms. So it's really hard to do this, really costly. So law firms are definitely not doing this as far as I understand. I think if anybody's going to do it, it's going to be an industry that has lots of common contracts, like finance, where they can get the economies of scale that make it worth this. I know there's some open source. In fact, I just met with some people today from there's a project called Ethereum, which is built atop Bitcoin, which is trying to build some of these the infrastructure of open source projects. Whether or not that will take off remains to be seen, but there's some open source infrastructure out there.
Thanks.
Mike? Harry, you may count this as financial or not, but it seemed to me that one of the areas that we found potential, was in the insurance industry, since the relationship between insurance companies and their customers are contractual. That was another possible place where computable contracts could play a role, especially since the contracts are in health insurance area, for example, are so complicated that it makes for a very asymmetric relationship between the insurance companies and the insured. And it's an area where I thought we might see more deployment of computable contract technology early on to make some of that information available in a computable form to the insurees, where right now they're unable to penetrate these multi-hundred page contracts. So you didn't mention insurance. I just think that is an area where we should definitely be looking for deployment of computable contracts. It's a little different from the case of the financial because it's been so asymmetric. These are built right now. Health insurance companies already have built these as computable contracts within their organization. They just don't make them available to anybody else. So it seems to me making them available more broadly would be a great example of computable contract technology and how it might serve society. Do you have any comments on the insurance area in particular?
Yeah, in fact, I was just talking about this morning. I think it's a really promising area for precisely the reasons that you outlined. Were very complex, but in reality, there are often just several core terms that can be severed off that form the heart of any contract, and in many cases, they're monetary in form. I think the real problem is you can frame it in kind of crude terms, which is, I believe it's follow the money, which is it has to be in the interest of the insurance industry to make it computable for them to start spending the money. So it was in the financial industry's interest to do this because they shaved off a lot of expenses in the trading. I think somebody has to make the business case to the insurance industry that they're going to save money, which I think is plausible that they might save money in this before they're actually going to start doing it. That's just my belief.
I think
looking around,
you just put your finger on exactly the problem there, which is that there's no incentive for some of the insurance companies to do that. However, there are two other options. One is that we did have some experience with auto insurance. Allstate, we were talking with Allstate, I don't know whether you were around for that or not, where they were willing and interested in seeing computable contracts because they wanted to provide a better service to their customers in the hopes that that would give them a better position in the market. They'd be able to crow that they have a better way of making their contracts available and also allowing people to mix and match contract terms on the fly. So that was one of the reasons why Allstate was interested in particular. And the second one is regulatory. It may be that we might be able to, down the road a way, see some requirements on these industries that they actually have to do this in some ways, although that's a different kettle of fish altogether.
Yeah, I agree. I'd say one additional benefit that occurs to me is we were talking about how computable contracts can be inputs to other systems. So right now, all state insurance companies have to do double duty. You know, they have an English language contract, and then they create a computable internal risk system. And it seems like you would eliminate the double work if you could just have the contract be computable at the outset.
Yeah, that's a great idea too.
Yeah.
All right.
I think it's a really promising area.
All right, Harry. Thank you so much for the introduction. And
Thank you for having me.
And feel free to stay on the line and take in the rest of the class. But we understand if you have to go.
Okay, I'll stay on for a little bit. I'll mute myself, but thanks for having me. Hope to see you guys in person soon.
All right, thank you very much. Turn it over to Ajay.
I muted myself.
Oh, there you are. We can hear you.
Okay, great. I'm just going to...
Oh, there you are. Yeah, so we just... Great. Okay, Ajay?
Can everyone...
Yeah,
Looks good, we can see it.
we can see it, and yeah, it sounds good. You may still want to turn down your volume just a bit, because I hear a little bit of a feedback too. But that's good. So anyway, so this is Ajay Agarwal. Ajay said, I should just introduce him as the unpredictable and rude Indian guy. When we talked recently, but I think a little bit more detailed introduction is in place. So Ajay, it's a real pleasure and honor to have you here with us. So Ajay is the co-founder and CEO at Syrian Labs. He's really a visionary in the legal technology space. He's been in the space for almost 20 years, and he's known for having founded United Lex, and led United Lex through tremendous success as a legal process outsourcing company. So, if anyone talks about legal process outsourcing, the first company you hear is United Lex, and then maybe sometimes people also talk about Pangea 3, but that's really, the big company, big companies that created this space really. And more recently, so before becoming a legal tech entrepreneur, Ajay was a securities lawyer. He worked for all the big brand law firms and investment banks that we know about, doing big capital and structured capital and securities work. After he then he got into United Lex, and once he left United Lex, he started Syrian Labs, which is a very interesting company that's working in the computable contract space. So Ajay is also a close friend of Codex. He's an entrepreneur in residence with our center, and yeah, it's been a real asset really to have Ajay involved in our legal informatics work here at Stanford. So Ajay has his LLM degree from Columbia University, an LLB degree from Trinity College in Cambridge, and then a BA in semiotics from Brown University. So Ajay will be talking about computable contracts and the future of transactional practice. So Ajay, over to you.
Okay, thanks very much, Roland. First, quickly, can everyone hear me clearly?
Yep.
Yes, perfect.
Okay. Firstly, I want to thank Harry for a really brilliant summary of the kinds of efforts that are out there in the space today. Listening to him really clarified my own thinking on the subject. As you very correctly introduced me, I'm much more of a doer and less of an analyst or a systematizer. So listening to Harry really allowed me to kind of see where my efforts over the last 7 or 8 years fit into the larger global landscape. So thank you for that, Harry. And what I'm going to talk about is a particular segment today of approximately $1 trillion worth of contracting, which is strategic outsourcing. These are some of the world's most complex and lengthy contracts. The average contract here is approximately 800 pages. And I'm going to talk about the efforts that we're making at operationalizing these contracts. This is post-facto operationalization. So in Harry's words, these are double duty situations where we have the natural language contract written, executed, negotiated in natural language, and then a post-facto, if you will, operationalization of the contract where some of the contract terms are converted into actionable computer language, and that's the domain that I'm going to talk about. And in order to understand what is it that we operationalize, I want to draw a broad distinction at the start between what I define as catastrophic risk versus regular business obligations. In these very, very long contracts, you find that a significant portion of that is addressed to the idea of catastrophic risk. And I think most people should have a fairly good idea of what catastrophic risk is. For example, things like data loss, which is addressed by data safeguards, confidentiality breaches, events of force majeure, and so on, are examples of actual catastrophic events. But in this category, we also include things like regulatory and policy compliance, for instance, complying with the FCPA, HIPAA, or insurance obligations, which will be driven by internal policy. And what is common between both these sets is that even though they are traditionally in the language of contracts obligations, they are not obligations that need to be monitored on a ongoing or even on a one-time basis. They stand, if you will, inside the contract, and they are conditionally triggered by certain extremely unlikely events. But from our perspective, the perspective of buyers who convert these into day-to-day business transactions, these catastrophic risk clauses are the first to get ignored. So they will remain, if you will, in natural language. And I can tell you, at least speaking from one particular domain, somebody invoked the insurance domain a little while earlier, and I'm talking now about the strategic outsourcing domain. This is likely to remain in natural language for the foreseeable future. What is going to get converted, and what we are doing, is converting the day-to-day business obligations into structured, actionable computer language. And so let me turn to that. This is what we call business obligations. If you look in this space, there will be several actions that the suppliers are supposed to perform that have associated service level agreements or key performance indicators, which in turn have defined financial impacts for either meeting or not meeting them. And what you see before you is an example of one such set of SLAs and KPIs. These are perfect examples of what is today captured in natural language that can be post-facto operationalized or converted into automated performance, and I will talk about that as well. same
Ajay,
is
what
the
does
case,
SLA
although
stand
this
for?
is the next and slightly more complex category of one-time deliverables, right? So for instance, completion of a transition milestone falls into that category. And what is common between the first two, the SLAs and the one-time deliverables, is that typically they have very defined associated financial effects. The other category is obligations which are expressed on a recurring or a one-time basis, but do not have a defined financial impact. But the performance of them still transfers, if you will, softer value to the receiving party, or if you will, to the buyer. And so this is the third category of business obligations that we focus on. So before I continue any further, I'm aware that I'm taking you very deep, very quickly into a domain that not many people may be familiar with. So do I need to go back to 100,000 feet and explain a little more about what is strategic outsourcing, or are people comfortable with the speed at which I'm going?
I think it'd be good if you could just talk about it from the 100,000 foot level for a minute.
Sure. So at the 100,000 foot level, this $1 trillion of value that I'm talking about that's transacted on an annual basis is dominated by IT outsourcing. Large enterprises, both public and private sector, typically outsource very large chunks of their IT environment to companies like IBM, Hewlett-Packard, and so on, Accenture, and so on. And so these arrangements, which are IT outsourcing arrangements, and may touch any element of IT infrastructure, hosting, application development, and maintenance, are one. In fact, they are the largest example of strategic outsourcing, and they are typically about $450 billion of value annually. Another example of that would be logistics outsourcing or facilities management. They roughly drive about $200 billion each of annual contractual value. And the fourth category would be what people commonly understand as business process outsourcing, or BPO, of which that's about $150 billion of annual contracts. So these are, if you will, the four standard components of strategic outsourcing. And what is common in each case is that a very large enterprise is outsourcing a core activity to a very large global supplier. And by the way, the suppliers who play in this club are fairly limited. Not more than 150 to 200 companies can operate at the scale that's required to deliver these kinds of applications. So does that kind of set the business context for people about what I'm talking about?
That's great.
Perfect.
The next thing that I'd like to talk about is how these, I mentioned that these are on an average approximately 800 pages in length. So I just wanted to give you an idea of how these contracts are set up. They are by no means a single unitary simple document of the type that Harry was showing a little while earlier. These are full-on, very, very, very complex arrangements. And if you see the image in front of you right now, you'll see the typical arrangement where you have a master services agreement sitting on top, and then dozens of exhibits beneath it. And within these exhibits, you have statements of work, third-party contracts, software asset listings, and so on and so forth. So the first object, really, the first challenge that we face is how to hierarchically relate all these documents to each other in a way that they can be represented in a hierarchical and nodal structure of the kind that you see. And that's a very important thing, because it establishes primacy of language. You will frequently find in these contracts conflicts occurring between various terms that are contained in separate documents. And the way you reinforce that primacy and operationalization is by setting up the hierarchy in the first place. Now, typically what you will find in systems like ours is that on the left-hand side, you will have the hierarchy represented, and on the right-hand side, you'll see a typical document viewer showing the actual contract with clauses that you're specifically focusing on. And these clauses can range as I said, on the catastrophic risk side, with all kinds of unlikely events, and then, and so I've given you some examples of that, or compliance and regulatory types of events, or it can concern, if you will, business obligations of the type that you're seeing now, which are performance obligations of a recurring or one-time nature. So this is how they are situated, if you will. The obligations that I showed you on the previous slide, this is how they are in fact situated in the larger document hierarchy. And I hope that this helps you to understand not just the kind of complexity, but if you will, the levels of documents that are in a typical business arrangement. So when I use the word contract, the first thing that I want to clarify is that I'm not referring to one document as in a simple derivatives contract, or if you will, an insurance document. These can be as many as 60, 70, 100 different documents that are tied together as part of a complex business arrangement. So to me, that complex business arrangement, if you will, is the composite entity that I'm talking about today, not any individual document within it. So, we talked a little about obligations. I just want to take a minute to explain how these contracts are managed today and what we see as the future. Most large companies today take these contracts, abstract them manually, and convert them in very large Excel documents which represent their understanding of what is supposed to happen and who's supposed to do what and do it well. And at the heart of this notion is the idea of what people usually refer to as deliverables and obligations. And the term obligation is actually a very key term. And I'm going to spend a little bit of time now talking about what we mean when we say obligation. So obligations, if you will, for me, are the language of performance inside a contract. And it's not obligation in the way that I was taught the language of obligations in law school. So I want to make this distinction now coming, if you will, from the computer science domain. In law school, we were taught that pretty much every will and shall is an obligation. So, they can span across the world of contracts and extend into the world of tort as well. Those are not the kind of obligations that we are focusing on today. In the first company that I started, United Lex, we had developed a system called LexBase, which had a natural language processing engine which would conduct semantic parsing of the contract and would capture pretty much every will and shall. And when we operationalized that system for a very large IT supplier, a company called CSC, to help them manage their federal sector IT outsourcing contracts, and these, from an 800-page contract, we could generate as many as 4,000 discrete obligations, which were associated with discrete obligation owners, if you will. And those reminders started pouring into people. They viewed them as spam, and that was not surprising at all. And that is why, over the course of the last 5 years, we've narrowed down what we consider meaningful business obligations and separated them, if you will, from the catastrophic risk category that I started today's talk with. And that, to me, is the real evolution, right? People have referred to the word hybrid or double duty in the conversations earlier. And this is a perfect example of that in action. A situation where you have elements that are computable sitting right alongside natural language elements that are catastrophic and do not, at least in the current scenario, need to be computed. The second point I want to make is standard electronic contract management systems, and I think Harry referred to these as well, today capture very limited data fields from these natural contracts. And they are more from a system of record than designed for their ability for actionable insights. And I will come to that distinction. The second, and this is also another very interesting insight, is that not all the data that is needed to operationalize the actions that are foreseen in a contract is contained in the contract itself. this is an interesting notion, right? I mean, people talk about computable contracts, but the fact of the matter today is one of the major obstacles to computable contracting is the fact that not all the information contained to operationalize these contracts is in fact contained in these contracts. And people regularly understand and are not surprised by this fact because it's assumed that you will state a few things in the contract and the rest of it will have to be manually done or performed by individuals in the concerned organizations. So, what is the future? The future, which I'm going to show you a little glimpse of, is to capture the nth level details about discrete obligations, to move the focus, if you will, from these very bulky data objects comprising 800 pages or 1,000 pages, and restore, if you will, the focus to discrete, unitary, molecular obligations, and and create a whole universe around A, what was expected, that's the contract, B, what actually happened, that's performance, and C, what am I getting billed for, and that's the world of finance. And if you track the obligation through these three various stages, then you can generate enormous enterprise value. And I'm going to show you some examples of that. So this, if you will, what you see on your screen right now, and I know it's a little faded, but can everyone see this particular thing clearly?
It's not really legible. We can see something there, but it's not very legible.
Okay, this is an example of how the system converts actual language obligations into an actionable obligation. And if you see here, there are several categories of metadata which are represented by these brown bars, basic information, other information, performance data, performance information, and so on. And then these metadata fields that are contained inside each of these tell you the categories of information that we are capturing. Again, all of this is happening post facto, right? So what is the description of the obligation, its development projects completed on time, what is the service level subcategory, its timeliness, what is the status, and so on. These are basic information fields. Then you have other information about its priority, for instance, its performance data, and below that you will also see its financial. This is the level, if you will, that a contract that was written in natural language needs to be, if you will, restated in computer language for it to become operationalized from a data perspective. So this, and now if you do that, then you can create a whole parallel universe around it, which shows the child service levels, references, and so on as well. So here, for instance, you will see its important dates, its function, its geography, and now you see when you talk about geography and stakeholders, you start seeing some of the information associated with that obligation that was not in the contract. And will never, for that matter, be in the contract, right? If there is a contract between IBM and Motorola, they're never going to say the person responsible for performing a particular obligation is Billy Graham, or from the supplier side, the person who approved it, or the client side, the person who will approve it is somebody else. This is information that you gather after the contract's been signed and it's been put into practice. So this is how they're coming together. Both sets of information, internal to the contract and external to the contract, are coming together in the form of key metadata associated with that obligation. So this, if you will, is the heart of the system. This is the notion of the obligation and how it's stated within the system. I'm just going to pause here for a second and ask if everybody understands the way I'm trying to elucidate the notion of an obligation here, because this is very critical to the operationalization that will follow thereafter.
Any question?
Okay?
Yeah, no. I think we're good.
Okay. So how do you make a contract come alive? How do you operationalize it? The first thing that we just spoke about over the last few minutes was understanding and mapping the distribution of expected business and financial value or outcomes, if you will, across the various obligation types. And those obligation types are derived by defining a set of business rules. What is and what is not an obligation. One very simple example being that I gave. which is drawing a distinction between the catastrophic and the business applications. Once you've done that, you have now ended up with a bunch of applications based on which, each of which has a defined amount of metadata. The next object then becomes mapping dependencies between the various applications. And what this does is that it creates a true neural network between the types of applications that are inside these complex contracts. Then the third activity becomes relating these obligations to discrete individuals who are either responsible for performing, approving, reviewing, or monitoring the obligations. Then the fourth level becomes when we start capturing actual performance data. And performance data can come, Harry gave one example in financial contracts where the data is coming from independent common data sources which express interest rates and currency values. We are talking about far more complex performance data. Here, performance data can come literally from dozens of different systems and individuals inside a large enterprise. And the way you do it is you create these either structured APIs or one-way programmed pushes where that performance data starts flowing into the larger system of record and starts getting reconciled with what was supposed to happen, right? I mean, the whole object, why are we doing this? We're doing this because we start by taking the contract, expressing it into a structured summary form as obligations, and then correlating it to live performance data wherever it comes from to map the delta between what was supposed to happen versus what actually happened. And then it can start maintaining discrete performance histories at the obligation level. The image that you see in front of you right now is one particular given obligation, and you can see how it's being performed over time, both graphically and in a tabular form. Now, one other huge problem in this, and I think Harry briefly touched on this, is the notion of heterogeneity in contractual nomenclature. I'll give you a very simple example. In our domain, you see this very often. So let's say that the supplier is entitled to raise his rates on an annual basis. There's an annual increment to the fee, and that's typically expressed as a percentage. So 4%, 5%, 6%. It's very common in our field to find one contract, we'll call it COLA, cost of living adjustment, the other one will call it annual price inflation, the third one will call it annual price adjustment. Now, if you were to do a simple structured data capture of the contract, then it would be literally captured as COLA, API, or APA, as the case might be. And later, if you wanted to run a comparison of those three suppliers on this particular underlying value, which is the annual increment, the system would be unable to perform that comparison for you because the headers of the same underlying property were expressed differently. So one of the major activities that needs to be done domain by domain is to map the horizontal variance of the same underlying business objects in very gigantic taxonomies that say, okay, so these are the, let's say, 15,000 different outcomes that can be expressed as outcomes in this particular domain. And here are the, let's say, 10 million horizontal variants of these 15,000 outcomes and associate them with each of those 15,000. And now, regardless of the way it's been written by any given person, you can start capturing and associating them with those horizontal variants. This level of complexity and mind-boggling breadth of taxonomy is necessary. Why? Because we are dealing with a universe where we are dealing with the natural language universe. Every law firm has its way of writing and drafting. Every client has their own internal policy preferences. And so as long as these variations persist, and all we can do is post facto operationalization of contracts, we're going to have to use these proxies, if you will. If the world was very simple and these billion-dollar deals were being done in an operationalized form like the derivative contracts that Harry referred to, we wouldn't have this problem. This problem exists, or the need for taxonomies exists, because at least in the foreseeable future, and when I say foreseeable future, I say at least 20 years, there is no way that these gigantic contracts can be fully automated. Any questions on taxonomies, guys?
No.
So this is a small example. This is a small example, literally at the clause type level of a taxonomy. It's expressed as a drop-down menu, and here you can see various types of obligations which are. Sorry, was somebody asking a question?
No?
I have one
Okay.
question.
Yeah.
That's one question.
So this is
we
an
have one
example
question.
of the different types of obligations that can be contained, and they have been expressed as a drop-down menu, and this is what I mean when I say taxonomy, right? So these are the horizontal these are the horizontal lists, the 15,000, if you will, and then they will have the millions of variants. And regardless of how the specific contract describes the outcome of an audit, it will get captured as an audit by the system. Why do we do all this, right? Apart from mapping the delta between what was supposed to happen and what actually happened, we want to be able to provide solid analytics on performing and contracting, trying to loop back to contracting and mapping risk. I think Harry briefly touched again on the concept of risk, and I will talk about risk in this $1 trillion domain in a little bit greater detail. If you do successfully, what I described earlier, this is the kind of analytics your system will be able to generate. You will be able to compare on an apples-to-apples basis suppliers and contractual arrangements that were totally heterogeneous when they were expressed in natural language, right? So you'll be able to compare suppliers against each other on performance, on risk, on finance, etc., and you can even generate balanced scorecards which express their overall ratings. You should be able to then compare, do spend analysis, project performance mapping, and even regional performance. In fact, what we find in this particular domain is that every unit of data has at least 3 dimensions. It's associated with a given function, IT, finance and accounting, procurement, etc. It's performed by a given supplier, and it's performed in some part of the world. So literally, you should be able to, the bottom graph that you see here, performance analysis by region, you should be able to click a button and automatically see that by supplier or see that by function as well, and that's exactly what's going on here. Based on the correlations between what was supposed to happen and what actually happened, we then are able to provide data-driven prescriptive feedback on how the contract could and should have been negotiated differently, and this helped our clients to renegotiate the contract when the term comes to an end. Right? And a simple example here is, it's showing you that by and large, you were under forecasting your actual usage during this period, and as a result of that, except for a little blip that occurred, if you will, in Q409, and adjusting for that deviation, you will see that typically any forecast needs to be discounted, if you will, by 6.5%. And this is an example of prescriptive feedback when negotiating or going from a budgeting cycle to a contracting cycle. So that's a very, very simple, quick journey, if you will, through a very complex and not so easy to understand domain. I just want to thank you guys for your patience in putting up with that. And I realize I haven't really done a great job of making this somewhat complex word come alive in your minds, but I wanted to focus on some of the techniques that we're using. In summary, if you go back to what Harry was describing, we are doing data-oriented contracts here. In other words, all the financial algorithms that are associated with service levels or penalties get expressed as algorithms within the system. So yes, there is that element of computer language, as Harry, structured computer language data, as Harry would call it. We also have elements of semantic contract data here, where we are taking words and we're translating them into computer rules about what can and cannot happen. And we're also doing automated assessment of compliance by associating contract data with performance data and using one to validate the other, right? We're also facing here the kind of issues and limits that Harry referred to, that there is a fair amount of indeterminacy that still exists with these contract types. One example of that is the category that I've carved out, which are the catastrophic risk obligations. But there are several others as well, which will continue to be there. What? Sorry, was there a question there, or am I just getting feedback?
That was feedback.
Okay. And, I mean, I think all of these issues will continue to subsist within the domain. And last but not least, the systems that we've created do serve as inputs to other computer systems. For example, Serial Labs, which is used to populate. So if any of you are familiar with enterprise software, you will understand that the most important bit of enterprise software is the ERP system, which sits at the heart of the enterprise. Typically adjacent to that, or as part of that, will be the F&A module, which contains typically the procure-to-pay or P2P module. This, if you will, is the core transactional engine that runs most large enterprises today. The learning of the last 15 years has been that in addition to the procurement functionality within the ERP system, people have invested separately in a large procurement system like an Ariba or an Antaurus. And that is ultimately what led to Ariba being acquired by SAP. Now, the problem with these larger procurement systems is that they are one-size-fits-all and they're designed for all suppliers. Now, you take a typical large enterprise, let's say, for instance, Barclays Bank, which has 3,000 suppliers, which manage collectively about $9 billion of annual expenditure. If you are capturing data in a uniform manner for all these 3,000 suppliers, there is no way that you can take any 50 or 100 of those suppliers and go very deep, right? Because that would break the uniformity and discipline that you've established. And the problem is that value leakage, at least at the $1 level, happens precisely within those special, or if you will, key suppliers. So that's what the system that I've just shown you and the approach that I've just tried to articulate is designed to do. It concentrates its focus on those key, very large, complex deals that sit within the system and subjects them to a magnified scrutiny. And then we provide structured inputs back, if you will, into what we call low complexity systems like ERP and procurement systems. So that's an example of how we're situated with the enterprise topography.
All right. Thank you, Ajay. Are there any questions? Mark, you had a question.
Yeah, I have one question related to the taxonomy. Is it only in English, or do you support multiple languages? Because then it's becoming more
designed on a Unicode basis, so it can be expressed in multiple languages. We are at this point working actively with 38 languages.
Great. Any other questions? No, then thank you, Ajay, so much for this overview. I know you have to run to another meeting, so thank you again for taking the time to speak with us. Thank you. Okay, so let's take a brief break. Let's reconvene here at 3:15. Okay? We'll get you
the breaks are
Thanks for using WebEx. Please visit our website at www.webex.com.
in India or in Singapore. I don't know. It's been even far away. Yeah. I have no idea. 17 hours.
That's so long. He is in the morning.
Is it daytime or is it next week?
It's morning 3:30. It's early morning 3:30. Early morning 3:30.
Yeah, it must be 12 hours.
3:40 actually.
12 hours? So Singapore. So normal people would sleep, right?
Yeah, normal people will sleep, but it has.
But he's a businessman, so he's waiting. His appointment was in bed.
He could build such a complex system, right?
Flying around the world all the time anyway, so. He's very. Huh? Yeah, better than from Colorado. Connection was better. Yeah, it's a little bit. Do you think so?
That's my.
Worked out fine. Oh, Richard's husband, yeah.
Oh, that was, yeah.
Yeah, that was because.
And now in Scotland was a system now. I have an office phone at my desk here. And I'm internally in the network in the Netherlands, so it's like I'm dedicated.
Oh, okay.
It's similar.
Oh, really?
Yeah, it's unbelievable. The technique is really fast.
Yeah.
It works.
You were.
Yeah. Yeah.
So I can see just having one side and both sides.
Yes. Yeah, it's related.
I never thought.
Okay, so she knows, yeah, he's really famous in the text. Yeah.
Well, I understand.
He's one of the famous text. Lawyers do. The tax industry in the Netherlands is quite big. Of course, yeah. It was always the other way around. Oh, your family. Now he's starting to get questions. Yeah, the other way. So he really likes it because he's
Building the brand.
yeah, he's retiring now. He only do, yeah, but I'm totally not what he is doing. Commercial, but he likes this. He shifted from commercial practice to yeah. Yeah. Yes. civil servant. In the Netherlands, it's another good. It's more fun financially. Yeah. Commercial practice, walk around.
Absolutely.
Yeah, that's yes.
You have to handle it.
Yeah.
And we don't
It's fine.
All right. Oh, it's right behind me. It's not picking up much.
security regulations. Capital markets.
Oh,
Apparently he just.
okay, so let's continue. So the next speaker is Harm Babik. So Harm's a legal tech entrepreneur from the Netherlands. He came to the US a little bit less than half a year ago.
3 months.
Oh, 3 months, okay.
3
Well, that's
months.
less than. And he sort of reached out to Codex and said, oh, it's interesting what you guys are doing, you know, I want to, get a little bit more involved. And so he started coming to our meetings and then said, hey, I've been working in the contracts management space for 10 years or so, right? So Harm built a company called Effect in 2002, I think. And he sees, he really sort of sees where contracts are going and what's sort of the future of contracts. And he seems to have a vision that's very much aligned with, so our ideas on computable contracts. And so we've teamed up with Harm and we've created the Stanford Computable Contracts Initiative. And we're very excited about this initiative. So Harm's a lawyer by training. He got his law degree from the Free University of Amsterdam. And, as I said, he's been a legal tech entrepreneur for, now, almost 15 years. And, worked with many of the, large companies, including ING Bank, IBM. He also works for Uber, a company that we hear a lot about recently. And yeah, so as a driver.
I need to make some living here.
It's expensive. He's trying to get started in Palo Alto. He started working as an Uber driver. So anyway, so just...
Yeah, thank you. Yeah, I made some slides. I want to go through this presentation. Hopefully we can have a discussion after the presentation. I have a lot of questions to be answered the next years, so I'll be happy to share some thoughts. Yeah, I arrived here in Palo Alto to develop business for my company in the Netherlands. And I met Roland and gave a presentation on what I'm doing with my company, and we called it e-contracting. So it's the same concept with another name, but basically, yeah, we help companies, automate legal services, and we work for a lot of Dutch companies, but also for U.S. branches of U.S. companies in the Netherlands, and we signed up a couple of companies last year directly in the United States, and that was the reason for me to move over here to build the business. And what we do is basically helping these companies automate all the legal services relevant for running the legal part of the business. And we have identified 4 different areas of legal services within the company. And we do a lot on corporate governance. It's related to the group structure. Some of my clients have 1 legal entity, but we also work for companies with 1,000 legal entities globally. So that's a lot of work that has to be automated to maintain the org chart of that group of companies. We do a lot of contract management. Legal work is for, I think, 70% related to contracts, either on drafting or maintaining or on disputes related to the contracts. So the dispute management is a large part of our automation. And a very important part is as well related to regulations, so compliance management. And with these 4 different areas of legal services, you can automate a lot of legal work within a company. And yeah, what we do in practice is all about knowledge management, information management, and that's why I'm really interested in Codex as an institute and in the combination of yeah, the math and the law school, because in a lot of cases it's an information problem, and with proper tooling you can solve a lot of issues legal people are dealing with all day. And this is the way it should work. When you map this to legal services, you can use these 4 parts of the legal service workflow, and you can try to improve all of these parts. And yeah, it's of course the 4th is the most important thing. It's providing wisdom to your clients to make the best possible decision. And yeah, it looks very simple. It's not more than that, but in practice we see a lot of problems. And one of the key problems is, of course, that legal services are very expensive. I think the global legal industry is about $500 billion, and that's only for corporations. So not only the individuals also have a lot of issues with the cost of legal services. So there is a lot of difficulty in getting transparency on the legal work. I always use an example in my practice that each of my clients is able to find an invoice of $100 for some tool they bought, but it's very difficult to find a partnership agreement within a company that has a multiple value for the company. But it's very strange how legal people work in transparency. It's not yet managed in a way that each of the legal agreements, rights and obligations can be presented with a click of the mouse. There is a lot of unequal playing field. The companies like Cisco, Google spend millions of dollars in investing on legal tech and other tools to be more advanced in contracting with counterparties. For example, if I want to sign a non-disclosure agreement with Google, I need to log into the system of Google and I need to sign whatever they present to me, and there is no way I can negotiate on the terms of that agreement. For a lot of companies there is poor risk control and it's very difficult to get access to the law. So I think, why is that the case? And the strange thing is that the legal industry is all about reinventing the wheel, and it's not only legal. I think it's related to all knowledge-related industries, because people working in knowledge will always try to preserve the problem to which they are the solution. And I think that's a really essential thing I have seen in the past 10 years. It's very difficult to change the behavior of the people I work with. So lawyers will stick working with Word, with email, and all kinds of other tools. And what I've seen here the past 3 months is that there is a wave of innovation. We have seen a lot of entrepreneurs presenting very exciting tools and solutions, but I think 90% of the solutions is only innovating not the problem, but it's all about treating the symptoms instead of fighting the cause. So e-discovery is all about the symptom of too much data, and you need to try to solve that, but they will not solve the cause by e-discovery. The problem still is too much data. So I think the real disruption will be in finding the cause and trying to solve that. And I stole this from Mike, one of his examples, and I made an analogical way of presenting what the cause of the problem is. So in the beginning there was only one rule, and if I look at my clients or even at my own situation, I think in my company we have hundreds of thousands of rules I need to take care of as a business owner. It's related to my clients, to my suppliers, to my employees, to my permits. It's unbelievable, and in theory it's impossible to keep track of all these rules. And most of the rules are very difficult to understand, and I think there is too much waste. This was one of the pictures I used in my first presentation. I bought a car here in Palo Alto, and I needed to sign 2 contracts that were longer than my wife. So it was impossible for me to understand what I needed to sign. And this gives me an example on how the legal industry is use these tools, because I didn't read it at all. So for me, there is no real value in signing a contract like that. And this is just a simple example of rules we don't understand at all.
So you're saying your wife is less complex?
But the big problem is, I think that there are so many different rules, and a lot of rules. I'm a lawyer. I try to read most of the contracts I sign, not all, but a lot of contracts I cannot understand at all. So I try to read it 10 times and I still do not understand it. So I think that the real problem, or the cause of the problem, is that we need to use modern technology to improve the way we do legal work. And computational law, I think, will change that. And maybe not this year, but in the near future, it will be changed very fast. And I think the Internet of Things will be disruptive, because not people alone are connected anymore. It's all about computers that are connected, and computers will interact, and computers will agree on certain rules. And there are a lot of examples already out there. I think the example of the financial markets and the way we sign for trillions of value agreements now by computers is telling us that it's not just a thing that will happen, but it's already happening. And why will it help us improve the law? Because the way social technology works, this is an example of Facebook. There are 1 billion people on Facebook. They use 240 billion photos in 1 trillion connections. So a company like Facebook is able to connect this all through graphs and other relations. So for a company, as an example, it's not impossible to create an own social network of all obligations. And big data and legal AI will help us solve that problem by enabling computers to redesign the law. And this is an example of a company or a movement Harry Cernan just mentioned during his presentation, but I think it's for you as a student really important to dive in this kind of evolvements. And it's Ethereum. It's the 2nd generation of Bitcoin, and Bitcoin as a contract is of course very interesting, because it's autonomous and there is no government at all. It's just a smart contract somewhere out there in the cloud, and it has real value. Ethereum is the next generation, and they have the goal to create autonomous, decentralized corporations. So the idea is that you create smart contracts in a kind of code, and these contracts will execute agreements on behalf of the people in that smart contract. And some business cases are already online, and one of the cases is rules for voting or rules for ownership. So it's very interesting to look at it, and from both the code and the legal perspective, it will change a lot in our daily work, I think, in a couple of years, because it will have impact on a lot of legal issues. And I think there will always be a key role for lawyers, also within the computational law, because a lot of decisions we cannot automate at all. And the reasons were also described in the papers for this week's course. One of the great examples was related to Mr. Newton, who already in, I think, the 18th century said that he was able to calculate the movements of the stars, but was not able to calculate the movement of irrational people. And I don't think that will be the case in the future. So I think lawyers will always be there, and they have a very important role in helping us using computational law as well. So the project I'm working on right now is the first step, and I think Harry Cernan made it possible for me to do this, because he said in his presentation, one really important thing is to compute, to make the law computational is really ambitious. It's difficult, there is a lot of law, so I don't think people alone will be able to make any impact. But with a computable contract, it's not that difficult. I do it in my business a lot, and also within a project like the Stanford Computable Contract Initiative, it is possible because a contract is nothing more than private lawmaking, and you can do it with just one rule. So it's very easy to create business cases that can be computable. So the research project I'm working on is to create sets of computable rules that can be used in specific business cases by contracting parties to draft and execute contracts. And yeah, I'm creating a theory that is based on more than 15 years experience with both legal tech and the law. And to be able to do some computational law, but in general, but in the computable contracts in a specific business case, you need a framework, and it's similar as the taxonomy mentioned in the previous presentation. We need to agree on some basics, and maybe we do not need to agree at all, but in general you can try to describe how you want to use contracts in a more computable way. And this is a theory I'm working on, and I want to try to test this theory in a lot of business cases out there within my customer base, but also in a lot of business cases we can think of ourselves. And this is an example of a computable contract I'm now working on. It looks not like a Word document at all, but it is similar as a Word document. But this is how a digital shareholders register will work. And it's just describing the theory I just presented in a more computable way with rules for how to calculate your percentage of ownership. And if you issue a new share, the calculation will give you an exact new percentage of ownership of that specific company. And these kind of business cases or test prototypes, I want to develop these here with the Codex Institute to try to help getting the world further in computable contracts. And this is one of the examples I received from Ms. Gardner. It's the example on why I think it's really important to think about the rules. This is a case of the Supreme Court, and it was all about the notion of prior to December 31st. And the Supreme Court had a ruling about it, but that's of course interesting. But the most interesting part is that there were 4 different opinions from highly respected lawyers on this particular rule of prior to December 31st. It's very difficult to make it computable if you use non-computable notion at all. And why you should use a rule like that if no one can understand. So I think to really solve the problem, you need to look at the cause. And the cause is using useless rules. And if you start using a rule that exactly describes what you mean with prior to December 31st, there will not be a discussion at all. So this is, I think, a very nice example of a business case we can work on. And the goal of the project itself is increase knowledge of lawyers on computable contracts. In the end, of course, build better contracts and reduce a lot of legal waste. Potential benefits, some examples. And also, of course, also a lot of potential dangers in the computable contracts are out there, and especially the examples in finance prove that it's not. It's really realistic that there are a lot of dangers out there. The flash crash with a wrong algorithm that created trading of $4 billion in 5 seconds that caused a crash at the stock exchange. And that's a real threat for computable contracts, of course, because the computers can execute agreements in nanoseconds. So it is impossible for us as a human to react in time. So that's what I'm working on. I just started, so it's just a first impression on what the project would look like. Any input is more than welcome. Yeah, I am looking for students that can help me during the summer in setting up the project and think with me on how we can make a next step. And yeah, one of the questions, of course, for today maybe is, this is, I think, a key question for you as a student. Is it important to focus on that the computer needs to learn legal language, or do lawyers need to understand more of computer language, or something in between? But in the future, I think for yeah, the successful lawyer, it's really important to completely understand what a computer can do for you. And in my practice, I encountered a lot of lawyers who were keen about that they didn't know how to use a computer. So they said, I know exactly where that contract is because it's there in that locker under that specific document. And yeah, I think as a proper educated lawyer, you need exactly yeah, know how the computer works, how you can use the power of the internet and big data in your daily routine. Because without, you will not succeed as a lawyer. And as a programmer, of course, in the legal space, you need exactly learn how the law works, and that there are a lot of opportunities out there, but still also a lot of yeah, things you cannot compute at all. So that's my presentation for today.
It seems like the middle path there is some type of kind of like what you see is what you get editor for a lawyer making a contract. So they can almost kind of like drag and drop. I want, you know, this type of term, I'll drop it into like the contract box. Then I'll edit what I want that term to actually say in natural language terms. But it almost like hints to the computer, this is the place to go to look for an application. Because I dragged like obligation, I dropped it in, and then I wrote about a new application. And maybe I do that a couple times and the computer.
Yeah, and the internet will tell you that why you use that obligation because 20 other lawyers use this one.
Right.
Or they will signal you, in this case, there was this obligation was used, but the ruling of the judge was like that. So
it seems like with a low modification, you could kind of almost trick a lawyer into they're just clicking some radio buttons and some next icons, yeah, but they're actually using natural language to translate that into something that's easy for a computer.
Yeah. But lawyers need to stop using Word, because Word is static, it's personal, it's not connected. So I think the business opportunity out there is create an editor for computable contracts. Because the editor lawyers are using now is all about Word. It's all about parsing natural language into a static document. But it should be more dynamic and more
I disagree. So, for the record, I think that's what he just suggested. It's very dangerous. And what is dangerous is you said you'll fall back to natural language. You'll use this thing to guide you someplace, and then you're going to use natural language. As soon as you do that, you've left the world of computable contracts, because now the computer can't understand it anymore. You have to get a human in the loop. So I like where you started to go, which was create a tool that will help you craft a computable contract. I think that's a fabulous idea. But the fallback to natural language is where we leave. Now,
as soon as you change a comma, you have no idea where you are.
well, that's a way of saying it, but basically you can't rely on having a human in the loop. The human has to be out of the loop, and today we can't understand natural language. And I didn't like your examples because the kinds of feedback you can get from computers today are exactly the kind of e-discovery things. Yes, I can, it sounds like what, anybody know the Watson program that solves Jeopardy thing? It's using techniques like that, it's just using a little word matching. It doesn't really understand at all what the meaning of the thing is. It's just sort of saying, okay, well, you must have been thinking about this because you're using the same words as these other documents are.
Yes,
you have
in
to
between.
truly understand it.
But
so
there is sort of hybrid.
I think we're going to be really careful here. There's a slippery slope one gets on as soon as you start to introduce natural language. It's a big step you have to take and leave natural language for a while. And eventually computers, you know, a century down the road may be able to deal with the natural language. But I think we don't want to start that because as soon as we do that, we won't create truly computable. By the way, just let me say about this. As far as I'm concerned, and I think this joke was made earlier, you know, lawyers don't use natural language at all. You learn a whole special language in law school. You use all kinds of fancy words that the rest of us don't understand. So you're already learning that language. And when you learn how to read LexisNexis things and where all the page numbers and the lines and so forth, you're learning a language. It just happens to be your language as opposed to this other language that you would need to know to write these.
Any other questions? All right, Sophia?
Yeah, so it seems like you don't like Word as kind of like a platform for interacting. But it seems like what are the limitations? Like, why couldn't Word be more like, you know, externally updated, or so that it is more dynamic, but it still remains the way, like the portal.
The way people use Word now.
Interact with it.
It's a presentation of a contract. And it's just what AJ is doing with his company. It's all about extracting already executed contracts. And I think the solution is that you need to start with creating a more computable contract. And Word is not the tool to create computable contracts. Maybe Word will evolve as well, and it will be a more computable way in presenting information. But now it's a static document. It's residing on your computer. If you send it out by email, there is a new copy. There is no. It's a very inefficient tool to use.
Okay, so I guess I've seen it, or I've heard about it being used for like document automation in general, not necessarily computable contracts, but they seem they have some similar properties.
Yeah, document automation is out there a long time. We do
Right.
it as well, but it's all about helping people creating a document with natural language. And of course, it's very useful, and it is more efficient than typing all the information yourselves, but the result is still a static document with natural language, and it's not computable at all. You can make it computable by converting it after the signature into a system like I sell and AJ is selling, but it has nothing to do with the concept of computable contracts at all.
All right, so well, thank you again. So now it's up to Eric and Michael to present their legal technology project. Excellent. And then next week, I think it's Johnny, David, and
everybody? Is everybody on
and
the
Phil.
schedule?
Next week. Everyone else is next week, right?
Oh, okay.
And you guys too, right? So next week will be a cluster of presentations.
Do you know how to switch between your
Sure.
presentation? Oh.
That's it?
Yep.
Great.
Right. So I will start off. So you can see from the title of our project, the sort of general idea is this question of whether you can use case citations, which are, for those of you who aren't necessarily law students, that's you noting in a brief that you write, hey, I'm talking about this case. What you're doing when you use a case citation, you're essentially signaling to the reader, but really to anybody, this argument looks like some argument that appeared previously. And so that's basically kind of like, you could think about it like metadata, right? It's data about the argument that you're making. And that's really the information we wanted to leverage with our project. So it's important to keep in mind, and this is something obvious, and we've talked about it a lot, I just wanted to kind of put it in your mind, right? Making legal arguments and thinking about stuff in the law requires having information. Information is what legal argument is. When you're making a legal argument, usually you're referencing some type of precedent. That's what defines the legal argument you make. But there's an interesting tension between information and accessibility, right? The more information you have, sometimes the more difficult it is to actually make that information accessible. So we got visited by case texts, right? So they make every legal opinion available online, but making sense of that information is really difficult. If you have every legal opinion online, it can be difficult to get access to the type of information you actually want that's relevant to the problem you're trying to solve. We learned about Westlaw and LexisNexis, right? They help solve this sort of tension by taking information, letting humans comb over that information, apply what are called head notes, and provide kind of a layer of accessibility to this massive amount of information. But that process of having a human read through a legal opinion and applying some type of accessibility marker is really expensive. That's why Westlaw costs a lot of money, and a service like Casetext can remain free, but it is a little less accessible. So we wanted to try and solve that problem, and the ideal way to solve the problem I just described would be something that automatically sorted a legal opinion. Right? It could read through a legal opinion and just flag it for you. Hey, this is about patents, or this is about this substantive area of law. Right? So the dream would be you take something like a federal opinion, which is a court of appeals in the United States. You could run it through some type of sorting algorithm, and the output would be, hey, this is about patents. Even more specifically, this is about patents and the patentable subject matter test. Or this is about family law. More specifically, this is about a specific legal issue in family law. Right? What that does is it takes something like case text, which is free access to legal information, but it makes it accessible, it makes it searchable. Even just applying that initial tag is super valuable. Right? Because if you can just get it in front of people, they can say that tag was or wasn't helpful. But if there's no tag, if there's no initial indication of what an opinion is about, nobody looks at it. It just sort of sits in a back room of the internet. The nice thing about legal briefs and legal opinions is that these case citations come in a very standard format, a format that to anybody who went to an American law school will be very familiar to you because it's a painful thing to learn. It's called blue booking. But it actually follows a nice format, right? And every part of the format contains a piece of information, from the names of the parties, to the court that decided the case, to the year it was decided, and things like that. So what we want to try to do, or what we tried to do with our project, was leverage these case citations, use the information that they contain, to automatically apply a tag that tells you this is what the opinion is about, just hey, here's a heads up. And we used case text. So I don't know how much you guys have looked at case text, but essentially what case text does is provide you a piece of a legal opinion and then tags that are applied by users that tell you what this portion of a legal opinion is about. So if you overlay a case citation onto that, what you can do is when you see a case citation that signals you, I want you to go, my argument looks a lot like the argument from this page of the Federal Reporter, from this other case. If you have information about that other case, if you have the tags that case text has, you can almost pull them through. So when someone says, my argument looks like an argument that appeared on this page of the Federal Reporter, and you know that on that page of the Federal Reporter, the types of arguments that were being made were about federalism and the Voting Rights Act, you can carry that information forward and start to intuit what this new legal document that you've never seen before is about. So we designed a program to do basically what I just described, which is sit on top of case text, read a new opinion, and then intuit what that opinion is about based on tags that I applied to different case text opinions, and specifically in the patent sphere. So the program first reads in these critical cases, so what I consider the 30 kind of most important patent cases that have been decided in the last 20 years. I go back 20 years because in 1995 there was a really important patent case that was decided. But mostly, look, I just tried to get modern cases that are heavily cited and also really influential cases that you'd expect if you're talking about patents, you're probably talking about one of these 30 cases. And then I want to link those critical cases to the tags like I just talked about. Step 2 is to read in a set of test cases. So this is a case the program has never seen before. It searches to see if it cites these critical cases, and then it applies tags from those critical cases to this new legal document. Based on all the tags it applies to the new legal document, it essentially guesses whether it thinks this opinion is or isn't about patents. And that's kind of the limited look that we did with this specific program. But you could imagine expanding that and building something where it carries through those tags and then makes assessments about all the different tags that it carries through, or all the different pieces of information this new legal opinion might have. And then the third test, what Michael will talk about, is we selected the actual way we tested whether this algorithm is accurate is by selecting 100 Federal Circuit cases from the last term, and then we let them sort. So we let the program sort out whether this individual case is about patents or not about patents, and then Michael looked at those same cases and determined whether they were about patents or not about patents. And the nice thing about kind of bifurcating that process is I was the one who selected these critical cases. So Michael had no idea when he was reading these, right? I should be primed looking for these particular cases. He was just looking at them as someone who is a lawyer who knows about intellectual property, reading a Federal Circuit case, deciding whether it would have been relevant if he had done a search about patents.
And then we just compared those results, so the program's intuitions against Michael's observations. And Michael can talk about that.
Alright, so first I want to talk a little bit about our sample, just so you know where the sample's coming from and the population we drew from. So all of our cases are for the United States Court of Appeals for the Federal Circuit. So this is a Court of Appeals that has subject matter jurisdiction over these particular areas of law. Most of these areas of law, how this will work is someone will bring a hearing before an administrative court, an administrative law judge. If they disagree with the way the hearing went, they'll try and appeal it, and the appeal goes here to the Court of Appeals for the Federal Circuit. So most importantly for us, this is the court that hears the appeals for patent claims, but they also hear claims under all these other subject matter jurisdiction areas. Most of our cases in our sample were Veterans Affairs cases, cases involving federal employee benefits, and patent. There were very few trademark and ITC or government contracts cases. So we drew 100 cases coming from the last quarter of the 2013 terms, and we had to remove 11 cases total. 5 cases were removed because after looking at them closer, there were no case citations in them whatsoever, and they turned out to be either really short orders or affirmations, a little one line, this court affirms this decision. And so those were completely useless for us, so we had to remove them. We also had a problem with 6 other cases that had to be removed for technical reasons, partially because CaseText seems to do something strange with their URLs, and that they're not completely permanent, so we get a list of URLs, run them, and some of them wouldn't work. And that was a consistent problem, but eventually we got it down to only a few that had to be removed for that reason. Also, some of the cases seem to have inconsistent source code that were incompatible with the program as we ran. So our results look like this. We have the test ran under 2 different parameters here. So threshold 1's on the left, threshold 2 is on the right. So threshold 1 means that the program read these 100 cases and tagged them as patent cases if they found any citation to a single one of our critical patent cases. Threshold 2, the program needed to find 2 citations to a critical patent case in order to flag it as a patent case. So as you can see, threshold 1 was more accurate. The validity was 75% as opposed to 67% in our threshold 2 parameter test, meaning that it just did a better job generally for this particular parameter. Both tests have a positive prediction value of 1, meaning there are absolutely no false positives, which is a pretty exciting find. And the difference in error between threshold 1 and threshold 2 came entirely from the negative prediction value. So basically, under threshold 2, the test missed several patent cases that should have been tagged as patent cases and were tagged as patent cases the first time through. And this is the same data, but displayed a little bit differently. So here you can see that there is absolutely no green segment. There are 0 false positives. So there was never a single case in which our test was ran, thought that the case was a patent case, tagged as a patent case, when it wasn't a patent case. It never happened, which was pretty exciting. You can see that the entire error, so the test had a 75% accuracy rate, but 25% was an error, which is that purple section there, and those were all false negatives. So every time the test made a mistake, it was under the situation where the test thought that a case wasn't, the program thought that a case was not a patent case, but I determined that it was. And if you're curious about the determination process, it really wasn't hard to skim a case really quickly. Usually you can tell within the first paragraph whether it is a patent case or not a patent case. So I'm pretty confident that I was at least 100% correct in finding patent cases. But yeah, so overall, the program did end up missing 58% of the patent cases under threshold 1. So our best case scenario, it did not catch a little over half of the patent cases. So limitations. The main limitation, we think, is just the number of underlying cases, the number of underlying critical cases. So we only had 30 or so that it was searching for, and if they had a larger web of cases to draw from, we think that we would have been able to catch more of those cases that we missed the tag on. But we also understand that as that web grows, that we might end up introducing more false positives, because if you're tagging more cases, there's a chance that you're going to be tagging cases that cited patent cases, but were not actually patent cases. We also had a problem with the number of existing tags under case text database. So the 100 cases that we drew from, the vast majority of them had no tags at all applied from case text. In fact, I don't think any of them had a single tag. So,
And just to jump in on that, so the one case I was talking about from 1995 is called Markman. It's a very famous patent case. Now modern patent cases have what they call Markman hearings. It's like a very prominent patent case. If you go to the Markman case on case text, the tag is just leading tags, right? It doesn't even tell you that that case is about patent cases. And so what I thought, what I kind of hoped early on based on suggestions I got was, oh, it would be really cool to just leverage all these really amazing tags, read them into the system, and then just fire away. And what I sort of realized is I had to go back and add in these tags manually. And I went to each page of these cases and tried to add in, okay, this page is talking about this type of patentable subject matter, things like that. Because when I was reading, I was applying more specific tags just to see what the program was capable of. But it was surprising how scarce the repository of tags, at least in the intellectual property space, was.
yeah, so that definitely held us back. We couldn't really rely on case text database tags, which made the process take longer and it's a little bit less accurate, unfortunately. Another interesting limitation, we have very high reliability on this test, so like I said, there were no false positives, which is exciting, but it could be a trait peculiar to patent law, because with a reliability of 100%, it's basically saying that every time our test tags a case as patent, it is in fact patent, because there are no non-patent cases in our sample that are citing our critical patent cases, which could mean that patent is just a very insular body of law, and there are patent cases citing other patent cases, and they never cite anything else. So we think that it's possible that once this branches out into other areas, non-patent, like tort, for example, it's very possible that the reliability will go down because there could be many other bodies of law citing tort decisions. And so we're envisioning something like maybe negligence standards that might come from a torts case but could easily be cited for contracts or anything. So in that case, we might end up with finding contract cases that are citing torts cases and would be tagged as a torts case if we kept that low threshold. So the reliability might get less positive, I guess, outside of patent. And then the inverse of that problem, our sample was drawn from a single court, and this means that our body of cases that we're looking at were all somewhat homogeneous. Like I said, the majority of our cases were Veterans Affairs cases, patent cases, and federal benefits cases. So we have no idea of knowing whether like a First Amendment case or a civil rights case would end up being tagged under this system. I'm guessing they aren't citing patent cases, but overall, this homogeneous sample does somewhat hurt our results. We also have the problem that since it's drawn from a single court, in this situation we had a uniform citation to draw from, but if you were citing, for example, state decisions, then sometimes state courts have very different rules of citation that can differ slightly from Blue Book standards, and so that hurts the uniformity of the process. So where we want to go next, we definitely want to expand the number of cases that we're drawing on, just because we think that will drive accuracy massively. We have fairly good accuracy of what we have now, and so we're thinking that as we draw a larger web of cases to draw from, then we'll get better results overall.
And just to jump in there, the limit, the reason I picked 30 was it was a time-intensive process. So what I initially did, what I sort of initially envisioned for the project was, it would be really cool if for every page of these cases, I had a series of somewhat specific tags. So I didn't just know if you were citing to the case Markman, you were talking about patents. I could tell you if you were cited to page 54 of this case, you were talking about the part of that case where they talked about the patentable subject matter case. And that was sort of the initial goal, and that's what was built out with these 30 cases. But you can imagine if you expanded that tagging system and kept that level of detail, but just built it out, and then we sort of mentioned it here, but also folded the program in on itself, right? So once it goes through and starts tagging cases, it can add the cases it's tagged back into some of those critical cases it's looking for, right? So that's really like, that's learning, right? The algorithm getting better because of the tags it's applying.
And it's worth noting that that process will work much better with a high positive predictive value, because we don't have to worry, right now at least, the program tagging cases erroneously and then carrying that forward. So that helps a lot. And the other limitations are expansions on what we mentioned earlier under the other ways we want to improve the program are things that cause us limitations in the past. We'll look at those shortly.
Yeah, and so that's our project. If you guys have questions, obviously that would be fun to discuss. Questions?
I have no question. I have just a recommendation. There is a project in Harvard Law School by Jonathan Zittrain, which he looked at links in the Supreme Court and the Harvard Law Journal, and he found that 70% of the URLs within the Harvard Law Review and 50% of the URLs in the Supreme Court leads to nothing, which the links are basically dead. We call that reference drop. And I think it might be interesting if you could look at it and see maybe something, some of the statements or some of the ideas might help you.
Andrew, you have a question?
Oh, I don't need to keep everyone. But I guess I was just gonna see, do you guys look at the ones that were excluded and maybe see, like, if you had a hypothetical case, would you actually need those cases? Because if it dropped cases that aren't really like super relevant, it might not matter that it didn't bring in every single relevant case.
I excluded, you mean the cases that were missed by the program?
Were those cases you would have wanted if you were a lawyer,
Yeah,
right?
yeah.
Yeah, I mean, we didn't really design the test to rank not just subject matter, but also like this also would be a useful case to talk about, because we were sort of thinking about it not necessarily from a practitioner's perspective, but really from kind of a legal database perspective. The important part being applying the initial tag to try and get it sortable and then immediately accessible. But yeah, I mean, that would be kind of an interesting next step. And I think we designed we built it trying to be cautious so we weren't applying the false tags. But that's an interesting kind of additional layer to think about, right? Maybe it's nice that we excluded some cases because they're not useful. Hate to keep people, but are there any other additional burning questions? Obviously, we'll stay.
Maybe if you stay around, then
yeah.
But yeah, thank you.
Thank you.